NACDL is the association of the nation's criminal defense bar.
Hello, everyone. Thank you so much for taking a case in the DC Compassionate Release Project. My name is John Albanis. I'm the resource counsel for the project. And I just want to say how important your work is to the success of this endeavor. We have had almost 20 people released from Bureau of Prisons custody as a result of your and your predecessor's efforts, saving over 270 years of incarceration, including 7 individuals who were serving life sentences. So thank you so much for the work that you have done and will do. And with that, I just wanted to give you my information and to provide you with some project updates that revise our initial training that we conducted several months ago at the project's inception. So with that, let me just share my screen. So there are a few updates from the original training. The biggest one being that the compassionate release statute in the district was enacted in permanent form prior to earlier this year, and this year being 2021. The law was only in temporary and emergency form, but now we have a permanent law, and the few statutory changes are as follows. So the temporary law said that the judge may modify the sentence if the judge finds the client is not dangerous, has shown evidence of rehabilitation, and extraordinary and compelling reasons. The permanent law, which goes into effect on May 24th of this year, says that the judge shall modify the sentence if those findings have been made. So there's no discretion to deny the motion if those findings have been made. Under subsection A2, which is one of the extraordinary and compelling reasons, the counsel in the temporary law said that the individual has to be 60 years old and have served 25 years. Under the permanent law, that provision now says 60 years old and 20 years served, so 5 fewer years. Under the elderly age provision, A3B, the temporary law said that the individual had to have served 20 years or the greater of 10 years or 75% of the sentence. And now the permanent legislation reads under the same provision, just that the client must have served the lesser of 15 years or 75% of the sentence. We said in the original training to email a certain judge a courtesy copy of the email. That judge had been handling compassionate release motion management for quite some time, but that responsibility has now shifted to Chief Judge Anita Josie Herring, and you can email her chambers a courtesy copy of the motion along with the appropriate motions judge at her law clerk's email address, allisoneller@dcsc.gov. On detainers, we wanted to give a little bit more information on detainers. We suggest contacting the local public defender's office for jurisdiction-specific information about this issue if the client does have a detainer. It is very specific to the jurisdiction with the retainer, so we suggest reaching out to those offices. There's a new motion format that went into effect after the original training was published. For the Superior Court's July 2020 standing order, you must list several facts on the cover page of your motion. The standing order is available in the resources section or the reference section under court procedure. The website for the clearinghouse is crclearinghouse.org/DC. And our resources have been updated quite substantially over the last few months. They now include, among other things, a searchable spreadsheet of Superior Court orders granting and denying these cases, a case summary document, and other voluminous resources about filing and re-entry planning. Please refer to these resources before filing your motion. They are essential to filing an effective compassionate release motion. And lastly, I just wanted to provide you with my contact information. Resource counsel for the project are John Albanus, jalbanus@nacdl.org. Please reach out to me with questions, and thank you again so much for your good work. And with that, I'll turn it over to the original training.
All right, hello everyone, and welcome to our first training for the DC Compassionate Release Clearinghouse. I am very excited today to welcome you to this opportunity to provide representation for many people who are seeking release from their incarceration during this extremely vulnerable time for our DC people. So with me today, I have several experts in the field of compassionate release, and I'm excited to introduce you. To get started, I'll introduce myself. I am Jamie Argento Rodriguez. I am Chief of the Community Defender Division at the Public Defender Service for the District of Columbia, and I'm honored to serve in this capacity to help coordinate the training committee, but I'm going to hand it over to the experts who are my colleagues. Professor Steinberg.
Hello, everybody, and welcome to our training. I am Jessica Steinberg. I am a law professor at George Washington University, where I direct the Prisoner and Reentry Clinic. I am deeply, deeply grateful that you are dedicating your time and your talents to helping DC residents petition for compassionate release. So I just want to really thank you for your efforts. We could not be launching this project without your dedication and participation.
All right, and Kavya Naini.
Hi, everyone. I'm Kavya Naini. I'm a staff attorney at the Public Defender Services Special Litigation Division, and I'll just echo everyone in saying how thankful I am that you're listening to this presentation and joining the effort.
All right, and last but not least, we have Stephen Logan.
Hi, I'm Stephen Logan, the Director of Digital Strategies at the National Association of Criminal Defense Lawyers. And I just want to echo the thanks in everyone's comments, and thank you in advance for all the work you're going to be doing on behalf of applicants to this project.
Great. I want to start by saying a thank you to all of the experts here who have joined me to get you all trained. And in addition to the folks that we've mentioned who are featuring here today, I'd like to spend some time thanking a group of amazing folks who have served as the collective that formed the Compassionate Release Clearinghouse. So I'd first like to thank the Washington Lawyers Committee, specifically their Executive Director, Jonathan Smith, the Deputy Legal Director, Emily Gunston, and members of their staff, Ken DeLong and Stacy Littner, who have dedicated hours of their time to collaborating with us and getting us started. I'd also like to thank the folks at Families Against Mandatory Minimums, otherwise known as FAM, specifically Mary Price and Juliana Andonian, the National Association of Criminal Defense Lawyers, also known as NACDL, where Stephen hails from, and specifically Norm Reimer and Stephen Logan. Further, I'd like to thank the GW Law School, specifically the Prisoner and Reentry the Prisoner and Reentry Clinic, led by Professor Steinberg, who's featured here today, and Maya DeMont. Next, I'd like to thank the Council for Court Excellence, Misty Thomas and Emily Tatro, for their leadership across the District of Columbia regarding our court practices and their leadership. And then in partnership with some of our firms that joined this collaborative, Wiley Ryan, led by Ted Howard and his team of folks, and then Aiken Gump, Steve Schulman, Abby Coleman, Margot Rusconi, Amanda Lowe, and Adrian Palma. And then I would be remiss if I did not thank the many, many defense attorneys who are in the grind on this every day, specifically members of the Criminal Justice Act, or CJA bar. They're represented on the clearinghouse by James Ziegler, who is known to many as a staunch advocate. And then the Public Defender Service, my colleagues, specifically Kavya Naini, who is featured here today, and my Deputy Chief for the Prisoner and Reentry Legal Services Program, Chiquisha Robinson. Moving on to the next. So today, what are we going to do today? We're going to cover very thoroughly what you're in store for when you agree to represent a person under compassionate release. Professor Steinberg is going to introduce you to the statute, this emergency legislation that has really been a gift to many clients, including some of my very own who have been reunited with their families. She's going to discuss how to work with your client and get started to prepare for the representation and litigation in court. And then we're going to shift to obtaining records and clearing detainers, important aspects of getting started. And then we're going to talk specifically about the filing procedures, and Kavya Naini will address that piece. And we're going to, at the end, shift into how to become a pro bono volunteer and the training that will be involved in that, as well as resources and where you're going to be able to look to find the information that you need throughout this process. I hope you enjoy the training.
Hi, I'll take over from here. This is Jessica Steinberg again, and I'm going to start with the statute, sort of the nuts and bolts. The COVID-19 emergency bill at section 304 was passed in March and created DC's first meaningful compassionate release program. The law was modeled after the federal compassionate release program, which was put together in the First Step Act of 2018. So if you are familiar with that act, this one is similar, but there are several differences. And the most important one, I think for our purposes today, is that there's no exhaustion requirement in the DC compassionate release statute. That means you can file a petition for your client directly with the court without having to submit a petition to BOP, the Bureau of Prisons, first. So today we'll only be talking about petitioning DC Superior Court for compassionate release. All right, I'm going to take you through all of the relevant portions of the compassionate release statute. First, the first thing you have to think about proving is that your client does not pose a threat to the community if he is released. And you want to keep in mind that the court is likely to do a full 360-degree review of the client and his history. The judge will consider many of the factors listed in the federal statutes we've shown here on the slides, but in short, the judge will look at the nature of the crime, any mitigating evidence, whether the sentence was proportional and necessary. The judge will look at the history and the characteristics of the defendant, and the judge will finally look at any evidence of rehabilitation while incarcerated. Now, this is actually very, very important and not up here on the slide, but part of showing that your client poses no threat to the community is putting together a solid release plan. That means showing the court what will happen when your client is released. Where will he live? How will he support himself? And how will he cope with his medical needs? So this release plan is an unwritten part of the law, but it's critical. Okay, so you've proven that your client poses no threat. I'm going to move now to showing that your client meets the substantive eligibility criteria for compassionate release. In short, he is eligible if he is sick, if he is older than 60, if he has COVID-related vulnerabilities, or has other compelling circumstances. So starting with being sick, I'm going to take you through each. Your client is eligible. Let's actually go back one slide and stick with these two criteria. So at the top, your client is eligible for compassionate release if he has a terminal illness. And what that means per the statute is a disease or a condition with an end-of-life trajectory. If your client has a terminal illness, he is eligible for compassionate release no matter how old he is. All right, so that's one way. Then the second bullet on this slide, Your client is eligible for compassionate release if he is 60 years of age or older and has served at least 25 years in prison. So if your client meets these two criteria, he can petition for compassionate release even if he is not sick. And then finally, your client is eligible for compassionate release if he faces other compelling circumstances. And these include, number one, a debilitating medical condition, so not a terminal one, but a medical condition that makes daily living a challenge: walking, feeding oneself, dressing oneself. Second compelling circumstance, your client is eligible if he is 60 years of age or above, has served 20 years in prison, and has vulnerability to COVID. And then the last compelling circumstance has to do with family circumstances. The legislation names two types of family circumstances that create eligibility for compassionate release. The first is when a family member who serves as the caregiver to the client's children on the outside, right? So this assumes the client has minor children on the outside, and the person who is the caregiver to that person, to those children, has either died or become incapacitated. That is a compelling circumstance recognized by the statute. A second family circumstance is if the client's spouse on the outside has become incapacitated and the client is the only available caregiver. All right, so that's the nuts and bolts of the statute. And I'm now going to turn to how you work with your client. The Bureau of Prisons is in a state of great flux right now. It is much harder than usual to get in touch with clients who are incarcerated, and some facilities are in total lockdown, meaning it will be almost impossible for stretches of time to get in contact with your client directly. So what we recommend is that when you get a case, you first get in touch with your client's outside contact. That will typically be a family member, but could also be a friend. Tell that person that you are the client's compassionate release lawyer, and ask that person to give your client a heads up that you will be in touch shortly. This will greatly facilitate the communication between you and your client. In addition to that heads up, ask the outside contact to have the client add you to his approved contacts list in CoreLinks, which is the prison's email system. That's important because you cannot communicate with your client via email unless he has approved you and invited you to join his CoreLinks account. So that is something that the family member can help facilitate. All right, a couple of additional pointers on initiating contact with your client. The first thing you want to do is to confirm his location. Clients are transferred from facility to facility with some regularity. So you want to Google the BOP inmate locator. It's very easy to find. Type in your client's first and last name or his federal register number, which we will give to you, and just confirm that you know where he is incarcerated. And then you have two options for communicating with your client confidentially. I mentioned CoreLinks, the prison's email system. It's a very efficient way to communicate, but it is not confidential. Emails are read. There is no attorney-client protection there at all. But you do have two options for confidential communications. One is through legal mail. We've provided comprehensive instructions in the written step-by-step guide for how to preserve your letters as quote-unquote legal mail. And you have to follow these instructions precisely so that your mail is not opened by prison staff. And the other option is to schedule a legal call. To do this, you'll need to call the main number of the prison, which is listed on the prison's website, very easily accessible. A switchboard operator will answer, and you will provide your client's name. You will then be transferred to either the client's case manager or the client's counselor. These are two BOP staffers who serve as your client's liaisons to the outside world. And it really varies by facility, whether it's the case manager or the counselor that you will work with. Don't be deterred if you have to call the prison's main line several times before someone picks up. This is quite normal. Just be persistent and you will eventually get through to the case manager or counselor. When you do, try to get that person's direct email address and phone number so that scheduling legal calls in the future is an easier task. All right, interviewing your client. All of you will do this by phone, most likely. BOP is not allowing visitors at this time, and we expect this to be the case for quite some time, although, of course, it's an ever-evolving situation. A word on privacy. Your legal call with your client is not recorded. That's what makes it confidential in the eyes of the BOP. But we want you to be aware that your client's case manager or counselor might be standing right next to him and might be able to hear everything he says to you. So if you're discussing very confidential matters, you might want to just be sensitive to this and ask your client if anybody is able to hear what he is saying. In the first call with your client, you'll of course need to carefully explain your role and the attorney-client relationship. A countersigned retainer agreement, which we recognize is the traditional way we all go about creating an attorney-client relationship. But that sort of formal countersigned agreement will really slow down the case, especially since BOP mail is very, very slow right now. So we recommend that you explain the attorney-client relationship orally, obtain the client's consent to the representation, and then simply memorialize it in writing afterward. Although, of course, we understand everybody will have to follow their own internal procedures on this. We have similar advice with regards to releases. You'll see in the step-by-step guide that you need to obtain several different releases from your client in order to gather important documents on his behalf. What we recommend is that you describe each release over the phone and obtain the client's consent to sign on his behalf. So just to be clear, we're recommending that you as the attorney sign the client's name with his consent, and then include your initials in parentheses following the client's signature so that it is clear to the BOP or the agency that you are sending the release to that you signed it on behalf of the client. The BOP has been willing to accept releases signed this way in the recent past. We can't guarantee it into the future, but we wanted to recommend it. All right, the remainder of your interview with your client should track the substantive eligibility criteria of the statute. You'll want to cover medical history. You'll want to cover the instant offense. This is a jargony word, meaning the offense for which your client is currently incarcerated. You'll want to cover institutional history, meaning his prison record. And here you want both the good and the bad. Has your client gotten good work evaluations? Has he participated in rehabilitative programming? And then on the flip side, has your client incurred any disciplinary infractions? And if so, what has happened? And then you want to talk to him about a release plan, which I referenced a few minutes ago. Where will he live when he gets out? Which family members will participate in his support on the outside? Now I'm going to turn to obtaining records and clearing detainers. I'm going to take you through some of the key documents that you will need to represent your client effectively, and then I'll explain how to go about getting these records. First is the pre-sentence investigation report, known as the PSR, or sometimes you'll see it written as the PSI. The PSR is put together by law enforcement after the client's conviction, but before his sentencing. This document is very, very important because it contains the government's official account of the instant offense. And so you'll want to talk to your client about the government's account and whether his account is similar or differs in important respects. The PSR also contains details about your client's criminal history, and it might be the easiest place to locate a comprehensive criminal history. The PSR will also contain details about your client's personal history, his background, his childhood. The PSR is considered contraband in prison, so it's very likely your client hasn't seen it in many, many years or even many decades. And so going over what it contains with your client will be important. Next is the Inmate Skills Development Plan, which is colloquially known as the Progress Report. I consider this the single most important record that you can get from the BOP because it documents your client's institutional history. It includes information about programming, it includes information about work history, about disciplinary infractions, about education in prison, and it includes staff assessments of your client. It's written in summary form, but it's a comprehensive document that covers most everything. Progress reports are created periodically, and so you should try to get the most recent one created for your client. Next is the sentence computation form. This document is key because it will help you understand your client's sentence and how much time he has left to serve. This form will also tell you whether your client has any outstanding detainers. More on detainers in a moment. I just want you to hold that briefly in your mind. And then we come to the chronological disciplinary record and the disciplinary hearing officer reports. These sort of speak for themselves. The CDR is a comprehensive listing of your client's disciplinary infractions in prison. And for the more serious infractions, there are also DHO reports, and you will be able to see in these reports what happened at the hearing and whether any sanctions were imposed. All right, more records. Medical records, you'll of course want these, especially the most recent ones. The inmate education data form provides comprehensive information on the client's education and programming achievements in prison. The inmate profile contains information on any actions taken by the client's unit team, including where he has been assigned to work. And the custody classification form will tell you what your client's security designation is. Okay. I've listed the documents. Now, how do you go about getting them? You have a number of options. The first step you should take is that you should request all of the documents we've listed from the U.S. Attorney's Office. We have hammered out an informal agreement with the U.S. Attorney's Office that they will try to provide most of these documents when they are able to. The PSR is a bit of a sticking point. They want attorneys to try to obtain it elsewhere, but you should ask for these records from the U.S. Attorney's Office, and the step-by-step guide contains instructions on how to do this. All right, you've sent that request to the U.S. Attorney's Office, and you are either missing some records or it's taking them too long to get back to you. I'm going to go through some other options that you have. One option is to ask the client or his family. Your client may have a stack of documents in his cell. This is actually quite common. You can ask him to copy those documents and send you what he has. Same goes for the client's family. It's not uncommon for family members to have records, particularly if there was a jury trial or a sentencing hearing. They might have a transcript. You can go through the BOP directly. Your client has a right, in fact, to request his records from BOP. He has what's called in the BOP regulations, which are gone into in greater depth in the written step-by-step guide, but your client has what's called an informal right of access to almost all of the documents we've listed, meaning he just has to ask his case manager or counselor for his records, and they should be made available to him. You can also make this request to the case manager or the counselor on your client's behalf if you have the proper release. I speak cautiously here because we have had varying levels of success getting documents from the BOP as quickly as we sometimes need them, but it is an option. That brings me to your next option, which is a formal FOIA request to BOP. So I've just discussed the informal right of access, but you can also go the more formal route and you can submit a FOIA request asking for specific records from BOP. And per the FOIA statute, BOP is supposed to respond in 20 business days. I can share that in practice, they will rarely adhere to this deadline. So you want to keep in mind how pressing your case is. Whether you're in an emergency situation, you may not be able to wait for a FOIA response. But it's an option. And we've included a sample of a BOP FOIA request in the resources section of our website. And then last option with regard to BOP is to go directly to the BOP medical records department for your client's medical records. All right, one final option for records. So I've talked about the U.S. Attorney's Office, the client and family members, the BOP. I want to name one last option, and that is submitting a FOIA request for the records we've described to the U.S. Parole Commission. But a big caveat here, the U.S. Parole Commission will only have your client's records if your client has had a prior parole hearing. But if your client has had a prior parole hearing, the Parole Commission will have most of the documents you need since they have already reviewed these documents prior to making their parole determination. So that's another place you can go for potentially getting these records. Okay, clearing detainers. I had you hold detainers in your mind a moment ago, and now we are back to them. A detainer is a hold from another correctional agency in another jurisdiction. It means that another correctional agency has unfinished business with your client. It may be that he has to face pending charges elsewhere, or it may be that he's already been convicted of a crime elsewhere and sentenced to time in a different prison system. Common detainers that we see are from ICE on immigration issues, from the Parole Commission if there is a pending parole violation, and from other states. So it's not uncommon, for instance, that your client may have a detainer from the state of Maryland or the state of Virginia, adjacent states, where he has been convicted and where he has still time to serve in their prison system. So recall the sentence computation form I referenced a few minutes ago. This is the form that will tell you whether your client has a detainer. It's very, very important to ascertain this, since your compassionate release motion will only address your client's DC sentence. If you win your compassionate release motion and there is still an outstanding detainer, your client will simply be transferred to a different correctional facility. So prior to filing your motion, we recommend that you do everything you can to try to clear your client's outstanding detainer. Especially if it's a very old detainer, this can be an achievable goal. I would love to be able to give you information on how to do this, but I can't because the process is so specific to each jurisdiction. So what I'm doing for now is issue spotting it, and you'll have to look up the rules in every jurisdiction in which you encounter a detainer and contact the prosecuting authority to figure out how you might clear it. And with that, I will turn things over to Kavya Naini from PDS to discuss the nitty-gritty of filing procedures in Superior Court.
Thank you, Professor Steinberg. So as Professor Steinberg just went through, there's a lot involved with preparing a comprehensive motion and getting the records you need and speaking with your client. But once you've done that, you're at the stage of filing. And so we just wanted to do an overview of what the timeline looks like for litigating your motion, as well as some of the nuts and bolts of filing in DC Superior Court. And before I get into the details, I just wanted to add a brief disclaimer that As of now, this statute, the compassionate release statute, has been in effect for a little less than 2 months. So as you can imagine, it's a work in progress in terms of figuring out an effective and efficient and fair filing timeline and filing procedures that work for all parties. So the information that you'll see and that I'll present is based on the protocol that's in place today and that has been operating for the past 2 months. However, there have been some growing pains, and it's likely that some of this information will change slightly in the coming weeks as the court has been reviewing whether it can make the process more efficient and fair. So with that in mind, I just say to be sure to refer back to the training and resources section of the website for the most up-to-date information, and just keep in mind that there could be potential changes in the near future. And I'll try to point out some of those potential changes as I go along. So now that you've done all of the work that Professor Steinberg went over, you're ready to file. There's 2 primary ways that motions are filed in Superior Court and how the compassionate release process gets started. The first is through a pro se motion that's filed by the client in their case with their sentencing judge or the judge that's been assigned to take over their sentencing judge's cases. Once that happens, the judge will typically appoint an attorney, and under the protocol that's in place now, that attorney would supplement the pro se motion within 3 business days. As you can imagine, that is a very short amount of time to accomplish everything that Professor Steinberg discussed. So it's been typical for people to request extensions of that time in order to file more comprehensive supplements. And going forward, that's likely to change slightly, that timing. The other way that motions get filed is if a client is assigned to an attorney prior to the court's involvement. In that case, the attorney and the client will decide when to file once they're ready, once they've received the documents, and depending on the urgency of the case. When they file, they will file on the docket in Case File Express in DC Superior Court, and typically you, as just a matter of practice, you'll send a courtesy copy of your motion and exhibits to the judge on the docket, as well as a copy to Judge Fisher, who's been helping manage the compassionate release process for all the judges and for all compassionate release motions. And you'll be able to find more detailed information about all of this in the step-by-step guide, but just keep in mind that you will be following these steps. When you email the judges, you should be sure to keep the subject line as compassionate release motion and to include your client's full name so that the court and the parties can keep track of the different compassionate release motions that are going around. So once you've filed your motion, as of now, the government has 7 calendar days in which they can oppose the motion. They are under an obligation to timely inform you if they plan not to oppose the motion, but they have 7 calendar days to oppose the motion if that is what they plan to do. Once their opposition is filed, you have 2 business days in order to file your reply. And while a hearing is not required, and I'll be discussing it a little bit more in depth in a few slides, if the judge decides that a hearing is necessary, then that hearing must occur within 5 calendar days of the government's opposition. So just keep that in mind when going through the timeline, because the resolution of your case might be slightly extended if the court, for instance, decides that a hearing is necessary. And so while I've gone through this timeline, there are of course unexpected emergencies that might arise. You might decide that you need certain documents that are taking longer to get. So the timeline can be adjusted through agreement between the parties and for good cause, and requesting that proposal to your assigned judge. As of now, the judge on the docket, if that judge is in the criminal division, will be the judge deciding your case. If that judge is not a criminal division judge, then there is a chance that the case would be reassigned at random to a judge within the criminal division. So that's something else to keep in mind when you're preparing your motion and when you're filing it, in case you're surprised by a change in who is deciding the motion. So the biggest piece of advice when it comes to preparing your motion for filing is just to give yourself a little bit of time. I think all of us have been in a situation where it's the 11th hour of a deadline and we're experiencing some sort of technological difficulties. The way that we file motions in DC Superior Court is electronically through Case File Express. And like all other technologies, it can be a little bit quirky at times. So you want to give yourself a little bit of time in advance of the deadline to make sure that everything is uploaded and filed properly. The biggest thing is to make sure that your document is titled properly as a compassionate release motion, because that will determine how the case assignments are made in terms of judges, and also how the judges, so that the judges understand that there is a timeline in place governing how the motion and how quickly the motion should be decided. When you're filing your initial motion, you want to make sure that there's a proposed order attached. And in Case File Express, you'll actually have to check a box to say that you've included a proposed order. And then in terms of the nitty-gritty of filing, you typically would upload your motion as a Word document, which Case File Express will then convert to a PDF. And then you will upload your exhibits either as a PDF or a Word document. And then Case File Express does the work of combining all of those documents into a PDF document, which you'll then be able to review before it's officially filed on the docket. The biggest problem or error that we've seen in going through the filing process comes with exhibits. So that is why you want to leave yourself a little bit of time to make sure that your exhibits are uploading properly and that they're not too large of a size. Sometimes what we have to do is to break up the exhibits in parts if they're too large to be filed on Case File Express in one go. And along with just giving yourself a little bit of time, you can contact the clerk's office when you're having technological difficulties, but just anticipate that under current circumstances, there might be some delay in getting responses to your questions. So that's why you, again, just want to ensure that you have enough time to make sure that filing goes smoothly. One big consideration that you want to think about when filing is whether the motion should be filed under seal. Typically, a lot of the information in these motions is sensitive information, whether it's about your client's background or family history, or whether it's about your client's health information, mental health information. Those are information that you want to be sensitive to the client's privacy. And so for that reason, you can file your motion under seal. It's a fairly straightforward process, but one that you should be familiar with when you're filing your motion. You would select sealed docket when you're filing your motion and prepare a motion for leave to file under seal that can be filed simultaneously with your compassionate release motion, and that the judge will ultimately grant or deny for the reasons that you set forth in your motion to leave to file under seal. When you are filing a motion to file under seal, you just want to clarify in your email to the court and with the government CC'd that you have filed your document under seal, so that everyone understands that this is a sealed document and they should treat it as such. If your motion to file under seal is granted, then you would file a redacted version on the public docket, usually as close as possible to your filing as you can. And one thing to keep in mind when redacting is that this can either be done in Adobe Pro, or if you don't have Adobe Pro, then you can redact your document in Word, print it out, and then scan it as a PDF and upload it to the docket as the public version. So as I mentioned before, hearings can be a part of this process, although they are not required under the statute. And for a variety of reasons, you might decide that you do not want to request a hearing, whether that's because you don't want to delay the resolution of the case, or because you don't think that the hearing will add much strategically to the litigation. Obviously, a judge can decide differently and might decide to hold a hearing, which is their right. For purposes of the hearing, you can decide to waive your client's presence, because especially under current circumstances, it can be difficult to set up video conferencing with the BOP or telephone conferences. However, if your client does want to appear at the hearing, you can speak with the BOP and let them know that there is a hearing that's occurring, that you need your client to appear by video conference or telephonically, and that's something that you can arrange with the counselor, with your client's counselor. Depending on the facility, there might be varying technologies for video conferencing, and there might be logistics issues, but this is all some things that you can discuss with your client and with your client's counselor. And with that, I will hand it over to Jamie, who's going to be talking about additional resources.
Hi, everyone. So far you've learned quite a bit about the statute itself and how to apply it and how to work with your clients and how to file in court and what to expect from there. So how might you access all of that information? Well, the good news is you've probably already been on the website, which just as a reminder, you can find at crclearinghouse.org. Again, that's crclearinghouse.org. On the Clearinghouse webpage, you will specifically look for the DC project. So there's a federal project and a DC project. So make sure you're in the right grouping of information. On that site, you will see a resources tab. And on the resources tab, you'll be able to access all of the information and examples of information and documents that Professor Steinberg and Ms. Naimi described. Specifically, there is a detailed step-by-step guide that outlines the process for getting started and beginning your work on these motions. There are brief summaries for compassionate release and Rule 35, which is a sister pleading. There will be sample FOIA requests. There are sample pleadings, including redacted versions of complex compassionate release motions, as well as reply motions that have been filed upon receipt of opposition from the government, and then court orders, both granting and denying compassionate release. So you'll be able to see directly how the DC Superior Court is reacting. So we encourage you to continue to check back in on the resources page. We will be updating the page as we receive information. And in that regard, if you have pleadings that you would like to share with the Clearinghouse, you may reach out to me and send them to me at jrodriguez@pdsdc.org, and we can ensure that they are placed on the resources page. In addition, if you receive orders granting or denying compassionate release, we would like to collect those so that we can share those also with your colleagues who are handling these matters. So, for those of you who are watching this presentation, have already raised your hand to say that you want to become a pro bono volunteer to represent people in compassionate release. We are asking that you also share, this information with your colleagues and friends and attorneys who may be interested. So again, if folks are interested in becoming a volunteer, they may go to crclearinghouse.org and click on all the tabs so that you can do the questionnaire and watch the training to become a member of the Pro Bono Clearinghouse. In addition, folks are also able to reach out to the Washington Lawyers Committee, who are handling requests or interest requests for people who want to become a member of the Clearinghouse. Jonathan Smith, the executive director, can be reached at jonathan_smith@washlaw.org. And then Emily Gunston can be reached at Emily_Gunston, which is GUNSTON @washlaw.org. Again, and if you have any problems, definitely go to the website. We'll be updating it regularly to inform about trainings, information, and resources that'll get you started. And next, I'm going to pass it over to Stephen Logan, who's going to go through the technical aspects of how this all works to make sure that the system moves smoothly throughout the process. Thanks, Stephen.
Thank you, Jamie. So as Jamie said, I'm going to walk through the system itself and help you get started. So first, the first step is, of course, getting started. As Jamie mentioned, you're probably already on this page, but just in case, the training materials are available at crclearinghouse.org/training. So if you just go to crclearinghouse.org, there'll be a link at the top for training. What you'll see there is you'll see two options, one for the DC Compassionate Release Project and one for the COVID-19 Federal Project. You can pick the DC project, you hit the Learn More button. and you'll be asked to log in. If you don't have an account, you can set one up. But if you were a volunteer with CP 2014, the Federal Clemency Project, State Clemency, the Federal Compassionate Release Project, or if you've ever used the NACDL website, you already have an account. So you may just have to reset your password, but you can use that to log in. You'll review the training materials, this video, and there's also a couple documents that Jamie highlighted, the step-by-step guide, as well as a guide to the system that are there for reference. Take a look at those as well. Maybe keep a copy of them. But keep in mind, as has been mentioned, all of our materials are living, so they will change as we learn more, as the process changes and things like that. So always be sure to go and check to see if there's a new version. Then at the bottom, there is a button, go to the questionnaire. This questionnaire is really important. This asks a couple questions about your practice, including what firm or organization are you with, which helps me get people in the right place. There is a non-disclosure agreement that covers information that you'll receive prior to engagement, information that we've received from the applicants or other records. So that's really important. There is an agreement that this is pro bono work, and that costs will not be passed on to the individual applicants or their families. And at the very bottom, once you get through all of that, there is a place to enter your email address as a digital signature. So what's going to happen next? You fill out your questionnaire, you'll receive an email notification that it went through and all of that. I will get that information. I have a report I pull, and then I will check to see if your firm or organizations are already participating, or if you're a small firm, solo, or working on your own, I can get you activated that way as well. So I look through all of that and check them and make sure we get people in the right places, and then I can activate your account. When I do, you'll receive an email notification, and if you're at a firm or organization with a case manager, they'll receive a notification as well. That gives you access to what we call the applicant tracking system. This is where we store all of the applicant information as well as yours, and do the assignments and all of that. When you first log in, there's 3 tabs at the top. Be My Account, where you can go to edit your contact information. Applicants, which is the main page, which will see the applicants that are assigned to you individually, and you can get to their records, as well as the reference section, which we've talked several times, but that's a really important piece that you go and you check out and you make sure that you have the most up-to-date information. Okay, so that applicants page. There, as I mentioned, you can search and you can see other cases that are assigned to your firm. You can see the cases that are assigned to you individually, as well as, and we've separated out, if there's cases that are closed out. So you can see a little screenshot there of what it's going to look like. The blue person, that's, keep an eye out for those blue icons. That's what will take you to, in this case, Mr. Doe's records. On the applicant record, we'll have everything that we have. Any correspondence or records or anything that we have will be there. You may see times where it said that this person has a prior attorney in their contact information. That's possible. Some of the applicants who are coming in may be former clients of the Defender Services or some other attorney who's not able to take on the case for whatever reason. So you may see information for that, but everything that we have will be there. There will be possibly PDFs of correspondence if they've maybe filled out a survey or anything like that. One thing I always mention is the first time you go to an applicant's record, always be sure to plug in take their BOP register number, which is the BOP number that tracks them in the Bureau of Prisons, and go to the BOP lookup and make sure that nothing's changed. It's unlikely people are moving between facilities with the lockdowns and everything else going on, but it's always good to go in and take a look at that as well. So what you'll see is on the left rail, everything's split up by the the kind of the category of information. I won't go through all of it. We won't have all of this information. And a lot of the information we have will be self-reported. But you can go in, you can see where all of this is set up. We try to split it up in a manageable way. You can also see there at the top is the applicant's name, the stage it's at, which I'll talk about in a few minutes, and then who it's assigned to. It's me. A couple important pieces in the applicant record. There is an engagement tab. This is really helpful for us. This is a place where you can indicate if you've initiated the engagement process or you formalized the engagement process. We want to try to follow up after we sign out cases and see if you need help or there are resources or there are questions and things like that. So if you can keep this up to date, it really helps us best target our resources. And it also saves us from emailing you asking how the engagement's going if you've already entered that engagement. So please go in and do that. This is available for the assigned attorney as well as the case manager to update this because each firm's a little different on how that's managed. The documents tab. So the documents are uploaded to the system. These are the documents I mentioned. They could be PDFs of correspondence. They could be questionnaires or other materials that we have. The documents that are uploaded into this section are encrypted and access controlled, and they're individually encrypted for each applicant. And so only the case manager, assigned attorney, and project staff, and that can include resource counsel, can have access to that. So if you're working with another attorney at your firm and the case is assigned to her, then you'll be able to see most of the applicant record, but you won't be able to see this. Only the assigned attorney and the case manager can access that. But y'all can pull documents out, share them internally, how you handle all of your cases, and you can do that. Closing. So I mentioned at the top that attorney review, and I called it a stage. So what this is for the applicants. So again, we can keep track of where things are and best target our resources. It's really helpful for you to go in and close your review. So there's only 2 steps in the process. It's the attorney review, that's the work you're doing, getting ready to file a motion, making all of those decisions, and then closed. So you can go in at the top of the applicant record, there's a green button that says a close attorney review. When you click that, you'll be taken to a screen that will ask you a couple questions. Have you prepared and filed a motion on behalf of this applicant, yes or no? If yes, the date that applicant was filed. And have you informed the applicant the status of their case? This is really helpful for us because we want to track outcomes. So it's really helpful to see, so we can keep track of where things are and the dates they go in, so we can see, maybe we can find patterns in all of this to find what's most useful. And so when a case is closed out, you still have access to it. You can still come in, but it just shows us that this one's done. And we don't need to follow up and ask you how it's going because we know that. The other point that I'll make here is when you do close out a case, take another one. We're going to have there's a lot of people who are in need, a lot of individuals who are in facilities who are scared, and this may be their best chance to get out. So we have applicants, we're getting all that set up. But, say you want another case. You've already done one, you're an expert at it, and you're ready to go. And one last thing, just to kind of capstone that, as we first get started, there may be a little bit of a lag as we get all the applicants in. So be patient with us, and we get their records set up and all of that. But tell your colleagues that you've had one, you felt well-resourced, and you're ready to move on. So I will pass back over to Jamie.
So I would like to say thank you to Professor Steinberg, Ms. Niney, and Mr. Logan for their amazing leadership on this and getting us organized. And we hope that you will ask us questions. If there are things that come up during your representation or after you received a court appointment, do not hesitate to reach out. Again, my contact information is J. Rodriguez, JRODRIGUEZ @ PDS dc.org, and I'm happy to field your questions, and we can get you in touch with the right people. We're very excited for this, and we thank you all for your commitment to this work, and we hope that you stay safe and be well. Take care.